Let me see if I can break this down for everybody. Miss Reynolds, you're saying there's a change of
Miss
circumstance.
Lemon? I'm
I'm sorry,
sorry,
Miss
just to make
Lemon.
sure.
Miss
Okay.
Lemon. Forgive me.
Okay.
I'm looking down at one of the pleadings and it says Reynolds versus Reynolds. So that's why
Right.
I'm looking down, looking at my notes and reading. And forgive me, but the court filings and the dockets will always say Reynolds. They don't change it to Lemon. It's
Right. I
what it
understand.
was
Yeah.
incepted as. So what we've got here is the basis for your change of circumstance is essentially that he changed jobs and that he the overnights went from 182 and a half to 185 versus 180. That's your pleading.
No, that is not. To clarify that, if you look at my pleading, it says that my job has changed, his job has changed, and that the original agreement was made under false
Well,
information. And
the original agreement has been ratified by the court, so I'm stuck with it. Okay. What is the change in your job?
I was a full-time student
Okay.
and doing real estate. And as we know, real estate has
Right.
tanked completely. So
Right.
have been trying to find a job now that I have graduated, but because of the, yes, corrupt nature of the court, there's a felony on my record, and
Mhm.
that should not be there. And so I am
Okay.
struggling to gain employment.
All right. Well, my problem is this. I need a major change of circumstance to review
That's
child support.
a major change.
That's been the problem all along.
All right, guys, buckle up. Today we're stepping into a tense courtroom showdown that starts off with confusion and control. The judge corrects herself, mixing up names, but quickly dives into Miss Lemon's claims that everything has changed since her last child support ruling. She insists her job collapsed, her life turned upside down, and the old deal no longer fits reality. But the judge's tone says it all. She's not convinced yet. The pressure is already building.
So you're saying you don't have an income now?
Correct. And Dave moved to Tennessee. I think that's pretty major too. He bought a house in Tennessee.
That's not
Paid
what
for
his
the
pleading
house.
says.
Excuse me?
Where does Mr. Reynolds live? He lives in, according to his response, he lives here in Grand Rapids.
Uh,
I live
when
in
I
Colorado.
requested this entire child support review, he bought a house in Tennessee, and he still owns that house in Tennessee.
He can own a house in Tennessee, but if he's living here in Grand Rapids,
Okay.
that's not a change.
Well, it
My
is
only my my
because
only question here is, since this, I need to know what his income changed because the job changed. So what information I need is this. I need information from his current contract. And if it is the same income, we do not have a change of circumstance and we're stuck with the 36 months by law. That's my
I,
explanation, Miss Lemon. That's why I tried to explain this. I'm like, I don't have the requisite change of circumstance to review child support at this time. You signed a contract in June of 2022. Essentially,
based on
when
the
you
information that David Reynolds was going to be, I was forced to sign that, claiming that that was the only way I could see my kids. Because if
unfortunately,
you're well
but there
aware,
was a lot to that agreement. They waived
yeah,
arrearages.
including
They
the
raid
fact that I would be able to see my kids, because otherwise I would
well,
not be able.
and you are seeing your children, correct? You are seeing your
Correct.
child. Yeah, okay, then
Only because I agreed to sign that.
you got the benefit of the bargain. And
Mm,
that's my problem. I don't have the requisite legal change of circumstance to review
I
this
completely
unless his
disagree.
income increased. If his income increased, I will review this. So what I need is I'm going to reserve on that because I want that information. Once I get it, I'll issue an opinion as to whether there's a change of circumstance or not. Mr.
And
so
he
I
does
can,
not have the kid. He does not have her 50-50. And nowhere in my pleadings did I say it's about a 2-day
Okay.
difference. That was a
Okay.
benefit that I was giving him to try to resolve things outside of
Right.
court.
Now the tension deepens. Miss Lemon argues she's facing unemployment, struggling under a felony she says shouldn't exist. She claims her ex moved to Tennessee and that alone should change the support order. The judge stays composed, cutting through each claim with legal precision. For every emotional plea, there's a cold procedural answer. The courtroom energy turns heavy as Miss Lemon realizes how hard it is to fight a system built on strict definitions of change.
But
well,
again,
her pleading says 2 overnights. That's
I
what
don't
she,
know. That's
It
what her
does, it does
pleading said.
not. Where does the pleading say that he only has 2 additional overnights? Please tell me where the pleadings say he only has 2 overnights.
I will look it up right now.
That's what
Please
I'm
do.
looking up to because I know that I read it in your pleading.
My request was for the child support to be based on 2 different overnights, but that was because of a conversation I had with Dave. which he claimed he would be willing to do if I would swap.
Minor
with
daughter
him.
Callie spends a minimum of 184 overnights with the plaintiff. That's
With
what
the
it
plaintiff.
says.
A
That's
minimum.
That's what your number 3 is. That's where I got the numbers from.
A minimum. That is not saying there's only a 2-day difference.
And I think you
but
have a
that is-
typo. Yeah, I think you have a typo. You probably meant defendant, but oh no,
No,
you
I
are the
didn't.
plaintiff.
No,
I'm
I
sorry.
didn't. I meant the
Either-
plaintiff.
either
I am
one.
the
You
plaintiff.
said
Either
184 overnights.
either
That's
one,
what you
your
said.
allegation number 3 indicates you guys have almost the same parenting time that was ordered in the previous order.
No,
That's
it
your own
doesn't- there's nowhere
That's
in
your
there
own
doesn't say that we
number
have the
3.
same parenting
Minor
time.
daughter Kaliana Reynolds spends a minimum of 184 overnights with the plaintiff.
But yeah, that does not say that's a equal split by any stretch of the imagination. Nowhere there does it say that Dave then has 180
yes,
some.
it does, Miss Lemon.
No,
Yes,
it
it
does
does.
not.
So I will reserve. Get me that contract. Let me see what the pay is. I will note the pay in the order. I'm going to let her know what that contract says. And if it says the $500,000 that you're alleging, there's no change of circumstance. Matter of fact, his pay went down $6,000. So,
Thank you very much, Your Honor.
This part explodes into confusion over numbers and custody days. Miss Lemon insists there's been a mistake, that her plea was misread. But the judge reads the document word for word, catching what she calls a typo that might not be one at all. You can feel Miss Lemon's frustration as the legal language traps her arguments. The judge stays calm, repeating the same line, no verified income change, no case review. The courtroom air feels cold and final as she reserves judgment.
all right. Have a good morning, everyone.
Have a
So
great
just
day.
to
I'll
make
reserve after I
sure,
see that.
the additional proofs that were requested, because I know last time that we sat before you, you would not allow me to show
I
the video. That was very clear
I-
evidence, even though Jude himself
Have you
had the
been-
exculpatory evidence.
have you been in front of me before? I don't
Yes.
remember you guys. Okay.
Absolutely, we've been in front of you before.
All right. You mostly
And
been in front
you
of Judge
would not
Semitis.
allow me to present anything, just like now.
Okay. Well, you've presented what you presented. That's what you've presented it by your motion.
No,
I
no,
read
my
your
motion
motion.
very clearly
Matter of fact,
says
I
that
read
I
it
have a
at
change
several-
of job. It
Okay.
very clearly says I have a change, both in my student status and in my job, that the father has a change, that it's not
Okay.
remained 50-50.
All right. Again, have a good morning. I'm going to reserve and I will issue it when I look at his income. Have a good morning.
Thank you very
Take
much,
care,
Your Honor.
everybody.
Just when the session seems over, Miss Lemon fires one last shot, accusing the court of silencing her before, refusing to even view her video evidence. Her tone carries anger and exhaustion, but the judge doesn't flinch. He reminds her the motion has been heard, the limits are set, and nothing moves without proof. The moment ends not with justice, but with quiet frustration. You can almost feel the courtroom deflate as she walks away, unheard once again.
We'll note the appearance of Mr. Todd on behalf of plaintiff, Ms. Podolsky on behalf of defendant. This matter is before the court on the plaintiff's motion for contempt, and the defendant has filed an answer. You did receive the answer, Mr. Todd?
I have, Your Honor.
Okay. Anything else that you'd like to add, Mr. Todd?
Your Honor, I will largely rely upon my motion, but even since we filed this motion, there have been substantial issues. On December 24th, Mr. Aldrich gave my client a gift, which was a heart stating "to my wife." The card attached, or the box attached, stated "2 honey buns from I will." And there was a poem inside of this gift. Additionally, there have been consistent messages outside of Our Family Wizard and outside of the scope of relating to the child. For example, there were substantial messages on January 9th about Mr. Aldrich's Bible study and asking why my client is ripping the family apart. We have tried to resolve this peacefully and tried to prevent it from going to this point, but I don't think this is just not resolving itself. So we are respectfully requesting he be held in contempt. We're respectfully requesting attorney fees for having to file this motion.
Thank you, Your Honor. As we've stated in our response, the plaintiff in this matter is not telling the court the complete truth. She often initiates these conversations. They are often not about the child. They have been about mediation, resolving issues. And when conversations break down, she's not getting what she wants. Then she files a motion for contempt and does not include her part in these conversations. I liken it to the behavior in a PPO. You can't get a PPO against somebody and then initiate that contact and ask that the PPO be violated. That's exactly what's happening here. She's calling, she's texting, she's using Our Family Wizard, but not including those sides of the conversations in her motion. We mediate this case on Thursday. We have repeatedly asked for co-parenting counseling so these parties can get on the same page with parenting their minor child. This is a family with deep spiritual roots. They are trying to guide their child spiritually in her religion through this very difficult time. My client has simply been trying to explain to the plaintiff what he's trying to do as a parent, how he's been feeling, how his brain works in these conversations when she gets angry with him because she's not getting what she wants. And then when he tries to explain this to her, she gets upset and files this motion. We do not believe that there should be any sort of contempt because this is just simply two people who are unfortunately going through a divorce. They're trying to navigate this process, having not done it before. And this is just simply not a case for contempt here, especially with plaintiff's actions not telling the court the complete truth. So we're asking the court to deny the request in its entirety, award costs and attorney fees, and we'll proceed forward with mediation on Thursday.
Well, it looks like you need to proceed on mediation on Thursday, but court does note that it does appear that there are disputed issues in this particular case that need to be addressed and to be again flushed out at that particular time. So we'll contact both of the offices and set a time for a hearing in this particular matter if you're not able to resolve things at mediation.
Yep.
Anything else, Mr. Todd?
Your Honor, do you need me to prepare an order, or will the court just set that?
No, we'll just set the matter for a hearing and be in touch with both of you.
Thank you, Your Honor.
Okay. Thank you. Have a good day.
You as well.
A new case begins. Different names, same emotional battlefield. This time, Mr. Aldrich's ex accuses him of crossing lines, sending personal messages, and even a romantic gift. His attorney fires back, claiming she's the one stirring conflict, leaving out her own messages to manipulate the court. The judge cuts through the chaos, calling for mediation instead of punishment. It's a quiet but telling end, another family torn apart by emotion and misunderstanding. Make sure to like the video, subscribe to the channel, and we'll see you in the next one.